Joanna, in this case, the Supreme Court has reformulated or clarified the test for when a de facto or constructive expropriation takes place. But what does that mean for the property development developer in this case, Annapolis, who alleges that the city of Halifax was trying to get their property as a park for free? What happens to their claim that Halifax took their property? What's next for them?
So what had happened was Annapolis had initiated a lawsuit against Halifax. Halifax had moved for summary judgment, which is basically just to have the case dismissed at a preliminary stage. The motion judge had rejected that and said that there was a serious issue to be tried. And then that was later overturned. So basically they can go back and bring this claim to trial under the expanded, revised, clarified test that we've just been speaking about.
So, Joanna, we talked a little bit about common law protections for property rights, which are sort of ancient. But what a lot of Canadians might be surprised to learn is that we don't actually have a constitutional protection for property rights. And it's very well known that our neighbors to the south have that constitutional protection. So, what can you tell me about maybe why we don't have a constitutionally protected property right in Canada?
Yeah, I would mention that Malcolm had a great piece during the Emergencies Act scandal where the bank accounts were frozen. That part of why that was so difficult to remedy is because we don't have constitutionally protected property rights. But that's just an aside. I thought it was an interesting tie-in. But anyways, it's not for want of trying. It was the policy of Pierre Elliott Trudeau. It was the policy of the Liberal government when they started negotiations for the Charter that the right to property should be protected. But for complex reasons, in part opposition of the provinces, some historical circumstances, some legal confusion in the final mix, property rights did not make it into the Charter. And we've certainly seen the repercussions of that.
Malcolm, is there anything you want to add to that, to our history of our Constitution, and uh, why those rights aren't enshrined, and maybe would enshrining them, give us better protections?
Yeah, I mean, I think there's a strong case to be made, and there's some scholarship by Dwight Newman and Laurel Binion about this. There's a strong case to be made that the exclusion of property from the charter was quite historically contingent. It could have been otherwise. For instance, if the notwithstanding clause was introduced earlier in the process, provinces would have had less reason to oppose it, I think. And similarly, there was some political maneuvering in Parliament where it seemed like the NDP caucus, who were opposed, were a little more effective than the Progressive Conservative caucus, which supported property rights. And so I think it really could have been otherwise. What impact has that had on Canadian law? Well, property rights aren't radically insecure in Canadian law, right? The political branches of government have some commitment to protecting property rights. But that said, there are cases of where abuse has taken place that could have been corrected by a constitutional protection for property. The Authorson case is one example where the government essentially immunized itself against claims by disabled military veterans, 2003 case. And similarly, the case involving the emergency financial measures. Whatever you think about the necessity of those measures, they had a huge impact on some of the people who were affected. And the fact that you may not have serious constitutional scrutiny because they only affected property interests, that's a serious matter. And so I think it has had an effect on Canadian law.
Malcolm, the Supreme Court gets into this a little bit in the Annapolis decision, but just because we don't have constitutional protections for property doesn't mean that we lack property rights, as you've said. So, what can you tell me about the inherent property rights that we have, and the sort of ancient nature of those rights at common law?
Yeah, absolutely. So there's a few different ways to approach this. Firstly, property rights are protected indirectly through the separation of powers. One of the big narratives of British constitutional history was over time the gradual development of constraints on the ability of the Crown or the executive to take property without being authorized by the legislature. So this requirement that if you're going to take property, the legislature has to actually authorize it, that's a kind of constitutional protection. It says the executive branch can't just take property on its own. And similarly, the courts have reinforced those protections. They've said that if you have legislation that takes away property, that legislation has to be clearly worded. You can't have, if there's an ambiguous statute, it should be interpreted in favor of the property owner. And the development of the doctrine of constructive takings or de facto expropriation, that's a further common law development that adds protections for property, saying that governments can't take away property indirectly through regulatory measures. And so you have a range of common law protections that are ultimately subject to the ultimate authority of the legislature.
We've got to go to break, but we'll be right back.